Okay, we're going to begin on chapter 6 of your text, which is titled Property and Debt Distribution. So we're going to do this over a 2-week period. We're going to spend the first week on property distribution and the second week on debt distribution. They do go together. When we terminate a marriage, we have to look at all of the premarital property, all of the marital property, all of the premarital debt, and all the marital debt. And then we do what I like to call horse trading, where we are going to take, you pay this debt, I'll pay this debt, you want spousal support, but instead of spousal support, you can have this asset. And so what we do is we put together basically a balance sheet. And then we start trading around to see who wants what. Okay? But there are a lot of things that you have to know about property and about debt before you can actually put everything together and start trading it all around. Okay? So we're going to spend this week on property distribution. Again, the first thing you have to know is that in every state except for Community Property Crazy California, we make a distinction between property that you bring into the marriage and property that you accumulate during the course of the marriage. That's going to get a little bit more complicated. That sounds so straightforward, right? If I brought my car into the marriage, I should be able to bring my car out of the marriage. Except, of course, if you were using marital assets to pay off the car's debt, or, of course, if you used that car to trade in on another car while you were married. It gets a little messy. But our first step is figuring out what you brought into the marriage and what was accumulated during the course of the marriage. Now, we're going to do first just a little bit of review of what property is. Now, I know you've had this in your real property class. I know you've had this in your wills and trust class. And we're going to do it one more time because you can't go over it too many times. There are some things in the law that go from one area to another to another. Again, if you don't know anything about debt law and bankruptcy law, you're going to have a hard time doing divorce law. And if you don't know anything about real property law, well, people who are married and terminate their marriages sometimes have real property. You have to know about this stuff. And so it's not like each little sub area of law operates within a vacuum. They're all layered on top of each other and interrelated. You know, if you remember math class, those Venn diagrams where you have circles that intersect, that's every area of law. There's a lot of intersection in some areas of law that you can't avoid. Property law is one of them. And so we're going to spend another minute going through real property law. Now remember, if you have real property, it's on land, right? Real property is land. Now, what about a house that's on property? Anything that is permanently affixed to real property is bundled with real property. Anything that can be removed easily or where there was no intent of permanency does not get bundled with real property. Okay, and so when we're talking about a house with a foundation and, bricks and everything that's permanent, that goes with real property. When we're talking about a mobile home, it's not. It's not permanently affixed to the property. So if I'm dealing with a couple and they are terminating their marriage and they live in a trailer, that is not real property. And that is going to be dealt with differently than real property. Okay? We're still going to have all the issues with that trailer about, was it premarital, was it paid for with marital assets, how much equity is in it, can it be sold, who wants to stay there, who doesn't care. We're going to have all those separate issues. But with real property, we have some very specific issues. And so it's very important to make a distinction between personal property, which would be a trailer or a mobile home, and real property, where a house and a garage are permanently affixed to the land. That makes them real property. Now, when we own real property, we can own it 4 different ways. How do we know whether we even own real property? Remember, there must be a deed. A deed is the written down transfer of property from the prior property, real property owner to the present property owner, and it shows who has title. Title is the word that we use for the ownership interest in real property. You can have title to a car, same idea, but when we're talking about real property, right, it's not like I can hold a piece of real property in my hand and say, see, I own it. You can't. You have to have a document that shows the prior real property owner transferring it to you, and a very detailed description of what was transferred and what you therefore have title to or an ownership interest in. On this deed, which will be filed with the county recorder's office so everybody can see it, that's the purpose of the county recorder's office. You have to remember, county recorders are there to hold pieces of paper, hold documents that we as self-governing people think are important for public interest. Deeds are one of them. If I want to go buy a piece of real property and I want to know who owns it, I'm going to go to the county recorder. And it's publicly known who has title to a piece of real property. It will also be on record with the recorder's office. Get it? Recorder's office. It'll also be on record with the recorder's office how much you paid for it, whether you owe a mortgage on it, whether you owe a second mortgage on it. Those are all public knowledge. Why? Well, maybe the owner wants to go and get a second or third mortgage on the property. The person who's going to loan money needs to know, hey, they already owe a ton of money where they use that piece of real property as collateral. Maybe I'm not going to be so willing to go ahead and loan the money then. So for creditors and for the public at large, the county recorder's office keeps for public display, as public record, who owns real property within that particular county. Okay? And that is through a deed that is on record. Okay. So on that deed, it is going to designate how you own that property. It can either be just an individual. Me, myself, and I'm the one who bought this piece of property. Okay? Or it could be joint tenancy. Maybe my sister and I bought a piece of property. Or it could be joint with survivorship ownership of a piece of property. and this is where it becomes important for domestic relations, where husbands and wives buy property together, joint and survivorship. Okay? And if I'm in California, crazy California, it's going to say I bought it as community property. Okay? And that's going to be in the very first paragraph of your deed. You don't have to look very far. It'll say this individual owns this property as an individual, as joint tenants, as joint survivorship, or again in crazy California, community property. Okay? So, what does all that mean? Well, if I own a piece of property as an individual, it means I own it, period. Now, sometimes that becomes important because let's say that I am 30 years old, I've never been married, and I want to buy a house. So I buy a house. And then I get married. What happens to that piece of real property? Well, I own it, me, myself, and I own it premaritally before I get married. Now, assuming I paid off the house, assuming there's no mortgage on it, that piece of real property is completely mine. I bring it into the marriage, I take it out of the marriage. Okay? It's premarital property. That happens a lot. Happens a lot with people who, especially people who marry later in life, they already own a piece of property and it's only in their name because they weren't married. Okay? Now, the next form of property ownership with more than one person is joint tenancy. Joint tenancy means that I own a certain percentage of the piece of property and other people own their distinct percentage of property. Now, it could be me and my sister, and maybe we both own 50%, or it could be me and my sister, and I own 75% and she owns 25%. The percentages don't have to be 50-50, and it doesn't have to just be two people. It could be 50 people, and we all own 1/50th. Or it could be 10 people, and we all own 10%, or maybe a few of us own 20% and then the rest is split up. But the important thing about joint tenancy is it is a distinct percentage that you own. That means if I own a percentage, I can sell that percentage. Or if I own a percentage and I die, that percentage then goes to my estate. Or, bring it around to domestic relations, if I am terminating my marriage and I have this 20% out here, well, that's a marital asset if it's bought during the course of the marriage and it needs to be split up. Okay? The third kind of property ownership, and this is the kind that we have most of the time, is called joint and survivorship. Joint and survivorship is this legal fiction, but it's there for a reason. It is, I own, let's say my husband and I, which we do, we own our house as joint and survivorship tenancy. That means I own 100% of the house and he owns 100% of the house. How can that be? That's 200%. We can't have that. Well, when you're married, you are considered to be one person. So this one person that consists of me and him both own 100%. That also means that if I die, my husband still owns 100%. And we don't have to fight about it in probate court. There don't have to be taxes. All he's got to do is go and change the deed. So it is a tool that we have in place to help married couples when one of them dies to not have to go through all the rigmarole you need to go through when it comes to real property. The problem is that if you terminate the marriage before one of you dies, then you still have to split up that property. And assuming the property was purchased with marital assets during the course of the marriage, becomes pretty easy, 50-50. But if I use some premarital assets to put a down payment on a house, and then there was some inheritance that came and we paid off more of the house, we have to split all of that out. Okay? We end up with this a lot because most married people, when they buy a house, buy it in joint and survivorship tenancy. It'll say so right on your deed. That means they both own 100% of the house. Together, owning 100% of the house, no big deal. But the math doesn't work if we now have two people, and now we have 200% of a house. It's a problem. Okay? Community property, again, wacky California says we don't make a distinction between marital property and premarital property and marital property. It's all lumped together. So don't even worry about it. We're just splitting everything 50-50. Makes life very easy. Not really equitable, but very simple in California. Remember, that's why California started prenuptial agreements, to get around community property. Okay? All right. So that is a brief little overview of what we're talking about when we talk about real property. Now, your married couples have real property sometimes, but they definitely have personal property. And in your book on page 112, there's kind of a list of marital assets or assets that marital couples have in their marital estate that we want to make sure we don't leave out. And it's pretty inclusive here. Antiques, cars, bonds, your clothing, maybe somebody owns a copyright, any heirlooms that have been passed down, jewelry, marital gifts, if there are any pending lawsuits out there, if there is money coming to the couple, it's a marital asset. Professional degrees, kind of like what we talked about with spousal support. If I helped put you through law school, that professional degree becomes part of our marital asset. Stocks, trademarks, appliances, bank accounts, business interests, collectibles, credit union accounts, same as bank accounts, household furnishings, your marital home, again, if we have one, and you also have to figure out how that marital home has been purchased. Pension plans, your 401k, your 501(c)(3) your IRA, profit sharing plans, tax refunds, trailers, artwork, boats, cash, condominiums, goodwill, which we're going to talk about, condominiums, which are a specific kind of ownership in real property, lottery winnings, insurance, mutual funds, pets. You have no idea how many divorces I've done that have blown up because they couldn't agree about the pets. Silverware, timeshares, vacation homes. This is not an inclusive list, but this gives you a flavor of what we're talking about, how we're going to split things up. Okay? Now, then on page 113 of your text, there's the case of Campbell versus Campbell. I'm actually going to have the discussion this week on Campbell versus Campbell and Bennett versus Bennett, which is on the next page. Okay? That deals with specific marital assets. And are they marital or are they not? Okay? Now, on page 116, your book sort of dabbles in marital debts. We're going to come back to that. I'd like you to go to page 117 where we talk about the distinction between separate and marital property. Ugh, is this a headache? This becomes a headache. Okay? Marital property is any kind of property that has been accrued during the marriage itself. Premarital or non-marital property is something that you brought to the marriage. There are other kinds of non-marital property. Inheritance is non-marital property. If my great-grandmother dies and leaves me $1 million and I'm married, that does not become a marital asset. That is a specific gift to me alone. Therefore, if Mr. Hetson and I get a divorce, which we're never going to do, then that $1 million does not get figured into our marital assets at all. It's mine. I set it over here. Okay? Inheritance is a specific gift that is excluded from the marital estate for the purposes of distribution of marital assets. The same goes for any kind of specific gift. If I am given a specific gift of a car for my birthday from, say, my parents, that car should be titled just to me and will not be part of the marital estate when it comes time for the distribution of assets in a termination of marriage. Okay? Now, inheritance gifts, those are pretty easy, right? There's a last will and testament, or there's an order from the court that says this is what you're getting. Now, a regular old gift, that's not so easy. Why? Well, because lots of times people don't separate out the gift itself, and so when it comes time for the termination of the marriage, it's hard to say, well, that car was just for me. If the title is not just in my name, well, then it wasn't just a gift for you. It was a gift for you and your husband. Okay? A lot of times, parents, believe it or not, know more than their kids. And a lot of times, parents will see that a marriage is going downhill and will talk to a divorce lawyer without their child to find out how to make sure their child has something when they get a divorce. And they will start doing things like giving checks. And I know this is an antiquated thing for people, but there still are checks. And the check will be made out to their child only, not to their child and the spouse, say at Christmas time. And the parents will make a copy of that check. So at the time of the divorce, the parents can say, no, we have all this documentation. This was just a gift for our child and should be non-marital property. Take it out. We're not going to split that. Okay? Same thing with cars. Sometimes even with homes. I actually had a client once my client was actually the father of a girl who he knew was marrying the wrong person and he was going to make sure his daughter was okay. He bought her a condominium. Just in her name. Didn't belong to the husband at all. It was non-marital property. Now, you can have fights about that, and believe me, we went through a fight with the spouse, but if it is a gift to one of the spouses, it's non-marital property. Okay? Insurance proceeds are kind of the same thing, not from a car accident, but if someone dies and there is a beneficiary in the insurance policy, and it's one spouse, not both, that is a specific gift to that one spouse and is non-marital property. Okay? If there are heirlooms, or if there are tangible pieces of personal property, not just money, that gets passed from generation to generation to generation, those are non-marital property, because it is an heirloom that is going to be passed through that particular family. Okay, and that is another kind of gift. Okay, are you seeing the theme here? If there's a gift, many different kinds, but if they're in the broadest sense, is a gift that is given to one of the spouses, it's non-marital property. Okay? So now that we know what's marital property and non-marital property, let's muddy it up a bit. Okay? What if I inherit... I had to take a sip to think about what I'm inheriting. Let's say I inherit $50,000 from my great aunt. And I say, you know, honey, our house really could use a new kitchen. How about we use this $50,000 and put it into the marital asset that we're paying for with our marital assets right now, and put in a new kitchen. And then 5 years from now we end up terminating the marriage. What happens to that 50 grand that we put into the marital asset? Well, there's this concept called transmutation. Kind of sounds like a Star Trek thing, right? Transmutation, where we do a mutation or a change of the original gift into something else. Money, you'll hear this in the news all the time, or if you do economics, money is fungible, it's changeable. Okay? So because a gift of money is fungible, it's very easily transmutated into something that is solid, like a new kitchen. But what do we do? It's not like I can just take the kitchen with me when the marriage is over. What we do is we do a valuation of the marital residence, the real property that we bought with marital assets, and we do a valuation of it with a new kitchen and the valuation of it without the new kitchen. So let's say without the new kitchen, the house is worth $100,000. With the new kitchen, it's worth $120,000. So the non-marital asset part of our house that gets taken out and off the table and is mine alone because of my $50,000 inheritance is $20,000. $20,000 is a lot less than $30,000, isn't it? Yeah, it is. But the way the law works is I'm not going to get dollar for dollar of value out of whatever improvement I make to the house. I'm only going to get that valuation that's over and above what the house would have had value of if we hadn't done that improvement. Think about it this way. What if I took that $50,000 and I wanted to put in a huge purple bathroom with velvet wallpaper and mirrors on the ceiling, and I spent the $50,000 on that? I may have decreased the value of my house by doing that. And so to make everything level and equitable, what we do is we say, here's the value without, here's the value with. If you lost money on the valuation, you threw away $50,000. If you got a part of that money back because you've increased the value of your house that much, that's what you get to keep. Okay? So that's one example of transmutation. Another very common example of transmutation is I'm driving a nice little Honda Civic when I get married. Then we have kids. I need a minivan. So we trade in my Honda Civic and we get $8,000 for my Honda Civic. So at the time we terminate the marriage, I still have the minivan. I'm going to be able to take $8,000 of the value of that minivan and transfer it over into my premarital, non-marital pile of assets. Okay, maybe the minivan's only worth $10,000 now. So $8,000 of it comes off to me, and then there's $2,000 worth of marital value that has to be split up. I hope that makes sense. Transmutation is a hard thing because you're always going to fight about the value of whatever this asset is. Now, when we talk about how do we figure out the value, let's say for a transmutation for a house, we have to have the house appraised, and that valuation will be considered by the court. Most of the time, each spouse will get their own valuation done by an appraiser. And then the court will look at both and usually splits it right down the middle. Okay? But appraisers don't work for free, and you have to pay for those. There's always an incentive for couples who are terminating their marriage to agree on an appraiser, but depending on how much they hate each other, they don't really care if they're spending more money or not. Okay, if they agree on an appraiser, then most of the time they'll say whatever this appraiser says, that's okay. Sometimes it works, most of the time it doesn't. Okay, and so you need to make sure that you have a good understanding of how this valuation process is going to work when it comes time to putting a dollar amount on whatever asset you're talking about. And we're going to use valuation not just where we have transmutation. We're going to use valuation when one party, one spouse wants to buy the house from the other spouse. Well, what's the house worth? Then you have to have an appraiser done. Unless you can agree on it, and again, depending on how much they hate each other, they may or may not agree on the value of the house. Or you get an appraiser come out and say, this is what the house is worth. Now you can split it. Same thing might be for antiques. You know, if you're a couple that likes to go antiquing, and you have to split these antiques that you've purchased over the course of your marriage, you have to put a value on them. Coin collections, gun collections, whatever kind of collectibles you have, you are generally going to hire an appraiser to come in and put a value on everything. And then you can start doing what's called an equitable distribution. Now notice I did not say the word equal because that's not always fair. Equitable means fair. So if I am the person who enjoys the antiques, then it's probably more equitable that I keep those antiques and give you, my spouse, something of around the same value that you really like. Okay? Equitable doesn't mean everybody gets split 50-50 down the middle. It means that we get to do some horse trading. You know, maybe I really like the living room furniture and you really like the family room furniture, and the living room furniture cost more than the family room furniture, but the parties don't really care. That's equitable because they're getting what they want, what they think is fair. Remember, we're talking about judges who know nothing about these couples. They have no idea what they like, what they don't like, what their history has been over the course of their marriage or even before they got married. And so the judge will look at both parties and say, okay, the living room furniture is worth more than the family room furniture, but you think it's equitable. You think it's fair that you take one and you take the other. And most of the time that's what happens. Okay? if you cannot agree, if we don't make an agreement about how we are going to equitably split stuff, well, then it's really easy for the court. The court puts together an auction, and at the auction, everything gets sold for 10 cents on the dollar. The auctioneer is paid, and then whatever's left money-wise gets split between the two parties. Done. So there's an added incentive for the spouses to come to some kind of equitable resolution. Now, do you have to have a valuation to have that? Not always, but sometimes you do. And so if we're really not sure what the antiques are worth, if we're really not sure what that painting that we bought at an auction is worth, if we're really not sure, better to get an appraisal, and then you can start doing the equitable horse trading. Okay? All right. Now, your book goes through some other kinds of property that become kind of tough to put a value on, right? If we have a business and the business has my last name to it and it's been a marital asset, the value of my name is important and it has value, right? Think about Macy's. Well, Macy was the last name of somebody, right? Or just drive around. You'll see companies that have family names. That family name has value. It's called goodwill. And it needs to be negotiated with. Now, what's the value of it? You're going to get a different kind of person doing that valuation. It's going to be someone who does business appraisals. We'll come in and look at the value of the business, how long the business has been in place. What if it's a business that's been in place for 100 years? More goodwill, more value. Okay? And so where we have businesses, this is something else that has to come into consideration. Okay? What if I've paid for my spouse to go through college? That professional degree has value and I helped pay for it. So we have a professional appraisal done on the value of that degree, and then it gets split. These are not easy things to split because they are intangible. Tangible means you can put it in your hands. Intangible means you can't. Okay? There are some other intangible assets that we have that are more commonly split up. And those are investments and retirement accounts. Okay? If I've invested in the stock market, right? Let's say I own a piece of Microsoft. I can't hold Microsoft in my hand, right? I mean, I can play with it on my computer because I'm using Microsoft, right? But my ownership interest is in a piece of paper that's called a stock certificate. How do we split those up? The value is then determined by selling the stock. And then the money divided 50-50, unless, let's say the husband says, I want to keep the Microsoft stock. And the wife says, okay, you will have to buy my interest. You'll have to buy half of my interest in that stock. Get a valuation on it, and then we'll see if we agree on it. Okay? Or, okay, you want to keep the Microsoft stock. I want to keep the car. We'll trade. Make sense? I hope it does. When it comes to 401ks, profit sharing plans, pensions, retirement benefits, basically, when you have a retirement account, you don't really own it until you reach the age of retirement. That's when you can actually take the money. So how does the court split up what we call a future interest? Right? I have an interest in my pension or my 401k or my individual retirement account, my IRA, but I don't have an interest in it today. So you can't really split it. What we do is we have an accountant come in and do what's called a qualified domestic relations order, or a QDRO. And what that accountant does is puts together, what amount of the retirement benefit is marital, what was premarital, when it's going to vest when someone turns 65, and then splits it so that whoever is investing for the pension or the retirement account knows that instead of handling one account, they're handling two accounts right now. Okay? Lots of times QDROs are not necessary because the husband and wife will say, you keep your retirement, I'll keep my retirement. If they've been working the same amount of time and making the same amount of money equitably, right? Not exactly. We come into trouble where we have someone who worked and was contributing to a 401k, then gets married, and then has to be told, well, you have to split up your 401k because it's a marital asset. What? That's mine. I earned it. I don't know why, but men especially have a really hard time with splitting their retirement accounts. And what we rely upon these accountants to do is split out how much money was contributed to this retirement benefit before the marriage and then during the marriage. And then even making it more complicated, let's say the couple's been separated while this divorce has been pending for a year and a half. That's when the marital interest will stop. And so we've got a block of time with going forward on this direction and going backwards on this direction. And then the qualified domestic relations order deals with that dollar amount. Okay? So it's qualified because it's a future interest. We're asking someone to do something in the future. Lawyers should always hire accountants to do this. There's a formula. If you're really good at math, do it. We hire accountants to do this for a couple of reasons. One, it is a complicated, complex scenario. The longer the account has been in play, the more complicated it is. And so you want to make sure it's done right. You also want to insulate yourself from liability, because if it's not done right, you don't want to get sued. The accountant is going to be on the hook, not you. Okay? So when we're talking about valuation of retirement benefits, things that we will be able to draw upon in the future, there must be a qualified domestic relations order or a QDRO. The judge will sign off on it, and then it will take effect in the future. Okay? Those are very complicated things. I'll be honest with you. I just always relied upon accountants because I got trouble with math. I'm not going to play around. Okay, so that's everything that has to do with distribution of assets. You can see where we're going to go with marital debts. Spoiler alert. We're not really worried about splitting things 50-50 when it comes to debts. We are really into equitable distribution of debts. So we'll do that in our next lecture. Make sure that you look at the discussion, because there is a discussion dealing with the cases that are in your textbook, and then I'll have some questions for you too. All right, thank you.